So, former vice presidential candidate and Republican governor of Alaska, former Republican governor of Alaska, Sarah Palin just lost two times in court trying to sue the New York Times over defamation. Let me explain. My name is Nathan Laurie. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. All right, today NBC News is going to give us the news about what's going on with Sarah Palin. And it's an interesting story because Sarah Palin essentially lost her defamation case against the New York Times. Let me give you a little background before we go into the story. Remember back when Gabby Gifford, she had gotten shot by some lunatic guy went into the, when she was speaking and shot her. And it was a big story. Some of the news media went on Sarah Palin, I believe it was one of her campaign websites or something. And on the campaign website, she had a map of like Democrats that were vulnerable. And she had crosshairs to show like, all right, we're going to target these people because they were vulnerable Democratic seats. So the media tried to align that with saying, well, hey, Sarah Palin's map is what sparked this guy to go and do what he did to Gabby Gifford. It was a big story. But then come to find out, this guy was just mentally ill, and her map and what she had put had absolutely nothing to do with, like, this guy had never even seen the map. He didn't know anything about the map. So back then it was a correction. Okay, well, this wasn't, this had nothing to do with her shooting. It was just political propaganda. Her map had nothing to do with it. So then later on, the New York Times did another story, and from the editorial board, where they made this claim again. It was like, okay, well, we're making this claim that the Gabby Gifford shooting was sparked by the Palin map where it was across here and then somebody went into it. Then it was kind of like, well, hold on, now you're saying this, but everyone knows that's false because before, when it first came out, we knew it was false. And now you're saying it again. So that gave us that, you guys had to know it's false. But then the New York Times, they looked into it and said, okay, we're going to make this correction. We're going to correct that lie, right? We're going to say, and they did. They made a big correction. So Palin then sued anyway. So now the question was her reputation harmed? And did she have a viable defamation claim because the New York Times had said this, years afterwards, knowing that it was false? And, was it a mistake or was it, actual malice? So they went through discovery and everything, and the judge essentially agreed that said, well, this doesn't rise to the level of actual malice. Now, I do have to say this for those of you who don't understand the defamation piece of it. The Supreme Court has allowed newspapers and publications a little leeway when it comes to defamation. Because if you make an honest mistake, they don't want you to be able to be sued because it has a negative effect on speech, right? If I make a mistake that I can get sued and lose on my job, then I'm going to be less likely to say something. So the Supreme Court said, well, it has to have some flexibility where people can make honest mistakes. And if you make a correction, then you don't have actual malice. But if you do it and you don't make a correction, or you do it for some poor reason, then you may have actual malice. So the New York Times' angle was that, hey, this was just a mistake. We corrected a mistake. The First Amendment allows us to do that, and the Supreme Court has allowed us to do that. Sarah Palin was like, well, you made the mistake, but don't forget this is, they made this mistake the first time, boom, boom, boom. Now they made it again years later, and, I've been harmed. So here is the story. So Sarah Palin is now 0-2 in her ongoing legal battle with the New York Times. But so far, the former Alaska governor has given no indication that she intends to stop swinging for the fences. Shortly after a federal jury in New York City on Tuesday dismissed Palin's second attempt to sue the newspaper for defamation, the Republican firebrand was asked if she would try to appeal the verdict to the Supreme Court. I hope so, she replied, as she climbed into a limousine. But that, legal experts, is easier said than done. Under New York law, Palin can't challenge the jury's unanimous verdict, which came down a day after U.S. District Judge Jed Rakoff of the Southern District of New York took the unusual step of announcing that he would be dismissing Palin's case regardless of how the jury had ruled. So you had two. He's like, I'm dismissing it no matter how the jury ruled, but let's see what the jury says. So Palin would have to try her luck with the Second Circuit Court of Appeals, perhaps arguing that the jury instructions misstated the law. But that court has historically been reluctant to second-guess determinations reached by jurors. Ryan Cummings, a media lawyer at Hodgson Russ, told Rutgers. And that's true. It's tough. If the jury came back and said that the New York Times was liable, and then the judge dismissed it, she's got a better argument. But you got two owls, it's going to be tough. It's like the jury found you, and on top of the judge said you really didn't have a case. I don't think she really has any, the appeal is going to be, because you kind of have two obstacles. Like the jury found you this found, the jury said no, and the judge said no on the law. So, it's going to be tough. Even if Palin were to prevail there, the odds that the nation's top court would take her case are against her, experts say. Yeah, because the Supreme Court takes very, very few cases. It's remarkable how few they take. She could try, but it's extremely unlikely that they would take her case, said George Freeman, who heads the Media Law Resource Center in Manhattan. They have bigger fish to fry, such as likely overturning established law in Roe versus Wade. I think the court would be loath to upset longstanding precedent in a second area. And that's true, because they're going after Roe. And just imagine they're going to strike down Roe and then go back to New York Times v. Sullivan. It's going to be tough. The second area Freeman was referring to is New York Times v. Sullivan. The landmark 1964 ruling, which concluded that a public figure must prove a defamatory statement was made with knowledge that it was false or with reckless disregard to whether it was false or not. Palin's failure to prove reckless disregard sank both of her attempts to sue the New York Times for a 2017 editorial the newspaper admits contained factual errors for which it had already apologized. So this is what I was talking about, that flexibility that you need. Palin is a public official. I think in the unlikely event the court takes a case revisiting Sullivan, it would be in a public figure celebrity case, not a public official case where the rationale for Sullivan is robust, uninhabited debate on public issues. And I think this is true. There's a difference between public figure versus public official. President would be a public official. I would probably be a public figure. That's the difference. Freeman, who previously spent 3 decades working as a lawyer for the Times, wrote in an email. Other legal experts concurred. So I'm going to go through. I don't want to read to you what all the other legal experts say. So here is what happened. Palin claims that her reputation was damaged by the Times editorial bearing a headline, "America's Lethal Politics," that incorrectly linked her to a 2011 mass shooting in Arizona that nearly killed then U.S. Representative Gabby Giffords, Democrat from Arizona. Remember, that's what I was talking about earlier. The Times quickly published a correction. No such link was established, and the editor then in charge of that section, James Bennett, issued an apology. So they had two. They retracted the story and issued an apology. But Palin sued the Times for unspecified damages. Rancroft tossed Palin's first lawsuit 2 months after it was filed in 2017, saying she failed to show that the newspaper knew it was publishing false statements in the editorial. But a 3-judge panel of the federal appellate court in Manhattan reinstated it in 2019, saying Rakoff should have given Palin's team more time to obtain emails and other evidence that might help her case. Still, as Palin's second defamation trial got underway, even her own lawyers expressed doubt she would prevail because the hurdles for public figures to prove that they've been liable are so high. We come to this case with our eyes wide open, keenly aware of the fact that we're fighting an uphill battle. Palin's lawyer, Shane Vaught, said in an opening statement. To win, Palin still needs to prove that the Times claim was not only false, but also that the news outlet published the claim knowing it was false. Both times, Palin was represented by Vaught and Kenneth Turkley, who helped Harry Hulk Hogan Balea win a huge libel suit that bankrupted media outlet Gawker. Yeah, he did. Tech billionaire Peter Thiel, a supporter of former President Donald Trump, bankrolled Hogan's lawsuit. Palin has refused to say who's footing the bill for her defamation lawsuit, stroking suspicions that her case may be a Trojan horse of sorts, galloping toward the Supreme Court to undermine Times v. Sullivan. So in other words, this is a test case. She wants this case to go to the Supreme Court. But Andrew Kumpelman, the John Paul Stevens Professor of Law at Northwestern University, said it's hard to guess what her long game is. I think her long game is simple. She wants to get to the Supreme Court to have them relook it over at New York Times v. Sullivan. She's already publicized a true narrative that the New York Times was sloppy with facts, and maybe that's all she wanted, he said. But is that really shocking anybody? Is anybody surprised that the New York Times is sloppy with facts? Like, really? Is anybody surprised at that? I don't think anybody's going to be surprised that the New York Times is sloppy with facts. But let me know what you think about this story. Do you think Palin lost horribly? She lost twice, and she's trying to appeal. Do you think the Supreme Court's going to take this case? I think it's not really going to happen, but we'll see. we'll see. It's interesting to see that, somebody's shadow funding lawsuits now against the New York Times. And the New York Times probably had to pay a lot of money for this, because don't forget, she had a one trial that was dismissed and it came back. So this hurt the New York Times bottom line because they had to pay for this. But at the end of the day, they prevailed. But I still think that it did hit the New York Times in the PR department because, the editorial board's not fact-checking well enough. And if that's the point, then I think she's won that point with spades. And let me know what you think in the comment section. Let me know if you like this analysis. My name is Nathan Lloyd, and I'm out of here. Peace.